Good morning, everyone. The meeting of the Commission on State Mandates will come to order. Welcome to the webinar. Statutes of 2023, Chapter 196, amended the Bagley-Keene Open Meetings Act to extend until December 31st, 2023, the authority to hold public meetings through teleconferencing. The Commission continues its commitment to ensure that its public meetings are accessible to the public and that the public has an opportunity to observe the meeting and to participate by providing written and verbal comment on Commission matters. Please note the materials for today's meeting, including the notice, agenda, and witness list, are all available on the Commission's website at www.csm.ca.gov under the Hearings tab. Also, please note that in the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Please join me in welcoming new Commission designee from the State Controller's Office, Regina Evans, Chief of Staff for the State Controller. Good morning, Regina. Good to see you. Heather, will you please call the roll?
Sure. Mr. Adams? You're muted.
Sorry, was having a trouble finding the mute button. I am here.
Great. Ms. Evans? We don't have any sound for you, Ms. Evans. I think she is frozen. I can see that she is there.
Oh,
Ms. Holman?
here.
Ms. Nash?
Here.
Ms. Olson?
Present.
Mr. Steppenshaw?
Here.
Mr. Walker?
Here.
Do you want to try Ms. Evans again, or?
Ms. Evans? Your sound is not working.
Okay, we'll help continue to work on the sound there, and we'll move on in the meantime. So the next item is item 1. Are there any objections to or corrections of the September 22nd, 2023 minutes?
Move adoption.
I
Second.
would say
Or is there any public comment on this item? Are there any questions from members? As the item was moved, I believe, by member Olson, and seconded by member Walker. Are we ready for the question? There's no further discussion. Heather, please call the roll.
Mr. Adams?
aye.
Ms. Evans? Ms. Evans, are you shaking your head in the affirmative? Yes, I can see a thumbs up there. A yes for Ms. Evans. Ms. Holman?
Yes.
Ms. Nash?
I was absent, so I'll abstain.
Ms. Olson?
Yes.
Mr. Steppenshaw?
Yes.
Mr. Walker?
Yes.
Thank you. Now we will take up public comment for matters not on the agenda. Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Is there any public comment? Hearing no public comment,
I'm seeing none.
we will move to the next item.
Let's move to the swearing in. Will the parties and witnesses for items 3 and 4 please turn on your video, unmute your microphones, and please rise and state your names for the record. You want to begin, Mr. Hill?
Chris Hill, Department of Finance.
Thanks. Mr. Guest?
Howard Guest for the claimants in item 4.
Thank you. Lucia?
Hi, good morning. Lucia Gonzalez with the Office of County Counsel for item 3.
Thank you. Fernando?
Good morning, Fernando Lemos with the Department of the Auditor Controller, County of Los Angeles for item 3.
Thank you. Dylan? Oh, Dylan, we can't hear you. I'll circle back to you in a second. Ms. Hagan?
Catherine Hagan for the State Water Resources Control Board and San Diego Water Board on item 4.
And then Michael Walker with the State Water Resources Control Board for item number 4.
Great. Thank you. Ms. Farabee?
Donna Farabee, Department of Finance for item number 4. Thank you.
And Dylan, do we have sound? Oh, no, still no sound. You might want to check if your, sometimes my cord comes partly unplugged and it can do that. No, you're having some technical difficulties. I'll try to get someone to assist you with that. In the meantime, would everyone please raise their hand? Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
Yes.
I do.
I do.
Thank you. Please be seated. Item 2 is reserved for appeals of executive director decisions. There are no appeals to consider for this hearing. Next is item 3, Commission Counsel Anna Barrett will please turn on her video and unmute her microphone and present a proposed decision on sex offenders registration, petitions for termination 21 TC03. At this time, we invite the parties and witnesses for item 3 to please turn on their video and unmute their microphones.
Thank you, Heather. Good morning, everyone. This test claim was previously considered at the September Commission hearing, but no action was taken. The test claim statute established a procedure for Tier 1 and 2 registered sex offenders to petition to terminate their duty to register as a sex offender 10 to 20 years after release from incarceration, placement, commitment, or release on probation or other supervision. Under prior law, all convicted sex offenders had to register for life. Termination from the registry eliminates the crime of failing to register for that person, and the process itself eliminates that crime for all in the class of persons who successfully petition. The Commission asked staff to answer a few questions for this hearing, which have been addressed in the executive summary. No changes have been made to the proposed decision, except to update the hearing date, chronology, the member information for the October hearing, and add the September hearing transcript to the exhibits and table of contents. Staff finds that there are no costs mandated by the state because the test claim statute eliminates a crime or infraction within the meaning of Government Code Section 17556G. Staff recommends that the Commission adopt the proposed decision to deny the test claim and authorize staff to make any technical, non-substantive changes following the hearing. Thank you.
Parties and witnesses, please state your names for the record.
Okay, I'll go first. My name is Fernando Lemos. I am the claimant representative for the County of Los Angeles. And I'll turn it over to Lucia Gonzalez.
Good morning. My name is Lucia Gonzalez. May I just inquire if witness Dylan Ford's mic is working now before I proceed?
May I test it?
Yes, thank you.
Oh, thank you.
Working
My
great.
apologies.
Okay, thank you. Claimant Los Angeles County is asking the Commission grant the test claim. We believe that the cost mandated that SB 384 did provide for a mandate on LA County and that no exemption applies. The commission staff is urging the commission to find that although the constitutional requirement for the state to reimburse the county applies, that an exemption also applies. The exemption being that a crime was eliminated. The county believes that there has been no evidence to support that contention. There is no crime that's been eliminated. The failure to register is still a crime. It still applies. And this segment of individuals that successfully petition under 384 would be inapplicable to be charged with the crime of failure to register because of their ability to successfully petition under 384. I'm going to turn it over to Mr. Ford for additional arguments.
Thank you, Lucia. And thank you, commissioners, for having us again for this particular item. And in the wake of our previous discussion, I was just trying to search for an analogy that I think might help illustrate the claimant's arguments here. With respect to section 17556G, again, the specific language is that the exception applies when there is an elimination of a crime. And as my colleague mentioned, as Lucia stated, no crime has been eliminated. Both the set of criminal offenses that are encompassed by SB 384, and furthermore, the penalty statute, Penal Code Section 290.018, are all unchanged as a result of the passage of the legislation. So all those offenses remain. So it's as if to say that like the crime, I think that the proposed decision's position is that it does eliminate crime for a potential class of people. But the statute itself does not say elimination of a crime or elimination of potential prosecutions. An analogy might be that if there was a law that directed the closure of a state highway, for example, so that people who normally take that road to get to work, to get to home, the closure of that road does not eliminate the crime of speeding. It just eliminates the possibility of speeding for that particular class of people. Furthermore, if there was a statute that directed the adjustment of the obligation to register one's vehicle at a different, rather than on an annual basis, to a different interval for certain class of people. Again, that doesn't eliminate the crime of failure to register the vehicle. It just changes the nature of the obligation. And furthermore, we're talking about potential prosecutions, which I believe that the proposed decision is sort of premised upon. We have to remember that the only people getting relief under this statute are the people who are following the law and are registering as required. So these are precisely the group of people who would not be prosecuted because their entitlement to relief is premised upon the fact that they are registering dutifully. On that ground, we would argue that this exception under subdivision G clearly does not apply because the crime has not been eliminated. Maybe the potential prosecutions are eliminated for a particular class of people. But again, this statute provides assistance to those who are following the law dutifully. So just as closure of a highway does not eliminate the crime of speeding, this particular statute does not eliminate the crime of failure to register. And thank you.
Thank you. Department of Finance, do you have any comments?
Thank you, Chris Hill with the Department of Finance. The Department of Finance concurs with the commission staff's recommendation.
Thank you, Mr. Hill. Is there any public comment on this item? Are there any questions from members? Ms. Olson?
So I'm getting stuck, I think, on perhaps it's a semantics issue, but I think it's a relevant semantics issue. And that is in the new executive summary. There's a really important word, I think, and it occurs multiple times in the executive summary, which is the word once. meaning after which. And my concern is that this actually creates a new administrative process, a new court process that local governments are required to participate in. And only after that process happens, is there this potential for this idea that a crime has been eliminated, so that there's this process beforehand that everybody has to participate in order to get to what our staff is interpreting as an elimination of a crime. And I think that's where I'm stuck. I kind of side with the local governments on this one because of that issue.
Anna, do you want to go ahead and respond to that, please?
My main response to that is anytime section 17556G comes into play, you're going to have activities that are programmed that under other circumstances could be reimbursable. The question now is whether or not there is a crime that is eliminated. And this process of going through the petitioning process and doing everything to terminate the duty register eliminates a crime.
Let me also add to that. As you recall, the County of San Diego case that was just recently decided by the 4th District Court of Appeal dealt with the other portion of 17556G, changing the penalty for a crime. There, the county was seeking reimbursement for the process to conduct Franklin proceedings in court. And those proceedings required evidentiary hearings and the submittal of information for the court to determine the youthful factors of the offender for the possibility of going to the parole board. There, the court held that 17556G applied based on the fact that as a direct result of those statutes, the possibility of that person's sentencing and penalty being changed was there. Here, it's the same thing. They're asking for the process to go through when a person applies for the termination of registration. So you're always going to have all of the cases that we've ever had dealing with 17556G always had a process that went along with it. And then it was still determined that reimbursement was not required. So that's not a change in the staff interpretation.
Okay, thank you.
Camille.
Thank you.
Thank you. Member Adams?
Thank you, Mr. Chair. I appreciate all the comments. I appreciated the updated information, but I too just cannot accept that there's been an elimination of a crime. Section 290 still stays in effect. What's changed is the addition of the tiered system that again adds required actions by local government. And this again, it changes the application of 290 to certain people and changes their reporting period. I would say even for those folks, someone who has a 10-year registration requirement and fails to report at year 5 can still be charged. So the only thing, again, that changes is how long they are being monitored. I will admit there are certainly long-term savings overall, both to the state and local governments. But in the meantime, there are short-term costs to local government. And if this is all hanging on the elimination of a crime, I just do not see that. I see the crime 290 still stays in effect. It's not changed at all, only how it's applied against certain people.
Well, sir, my response to that would be to consider the other previous test claims that we have decided on 17556G grounds. For example, the case that Ms. Gonzalez was brought up at the last meeting, the 1997 TC 15, which was also about the sex offender registry. And in that case, they had expanded the list of crimes that create a duty to register, and in expanding the list of crimes that create a duty to register, even though it didn't affect the statute that is used to enforce the duty to register, it was still found to be have created new crimes because the people who were guilty of those added offenses would not have been guilty of a crime prior to the change in law. Similarly, there is also the other test claim that we referred to in in the proposed decision, the felony murder case. In that case, we found that there was an elimination of a crime because in that case that they had changed the statute that is used to describe who can be charged for felony murder to exclude people who do not have intent to kill when they were committing their felony offense. And in that decision, we found that had eliminated crime. In this case, we have found that people who do not have a duty to register under 290 no longer can be charged under 290.018. Therefore, a crime has been eliminated.
I appreciate that. I would note in the felony murder rule case, I was on the minority voting on that I disagreed in that issue, and I hope that maybe someday that's litigated. Thanks.
Regina, you're now muted. All you'd have to do.
Okay, thank you for the questions and discussions, and also thanks to staff for providing information in response to questions that were raised at the prior hearing. With that, is there any further discussion?
I'm seeing no hands raised.
Okay, is there a motion?
I move to adopt staff's recommendation.
There's been a motion. Is there a second?
I'll second that.
It has been moved by Member Walker and seconded by Member Holman. Are we ready for the question, or is there additional discussion? If no further discussion, Heather, please call the roll.
Mr. Adams?
No.
Ms. Evans? Circle back. Ms. Holman?
Yes.
Ms. Nash?
No.
Ms. Olson?
No.
Mr. Steppenshaw?
Yes.
Mr. Walker?
Yes.
Ms. Evans? Are you able to speak? I know you just got your phone working.
Yes.
Thank you.
Thank you. Motion, I believe, is carried with 4 yes votes.
That's right, 4-3. Next, we will ask presenters for item 3 to please turn off their video and mute their microphones. And next up is item 4. Chief Legal Counsel Camille Shelton will please turn on her video, unmute her microphone, and present a proposed decision on order number R9-2009-0002, adopted by the San Diego Regional Water Quality Control Board, 10 TC 11. At this time, we invite the parties and witnesses for item 4 to please turn on their video and unmute their microphones.
Thank you, Heather. This test claim alleges reimbursable state mandated activities arising from 10 different sections in a 2009 stormwater permit issued by the San Diego Regional Water Quality Control Board for the permittees in Orange County. Staff recommends that the commission partially approve this test claim for the following activities from December 16th, 2009 through December 31st, 2017. Number 1, develop a monitoring plan to determine stormwater action level compliance. Number 2, update the map of the entire stormwater sewer system in GIS format and submit the GIS layers to the regional board. Number 3, comply with the new mandated activities identified in the conclusion relating to the effectiveness assessment of the jurisdictional runoff management plan and the work plan to address high priority water quality problems. Number 4, gather and include in the annual report the new mandated information identified in the conclusion. And number 5, annually notice and conduct public meetings to review and update the watershed work plan. Reimbursement for these activities is denied beginning January 1st, 2018, because the claimants have fee authority sufficient as a matter of law to cover the costs of these activities pursuant to Government Code Section 17556D, and thus there are no costs mandated by the state. In addition, reimbursement for these activities from any source, including but not limited to state and federal funds, any service charges, fees, or assessments to offset all or part of the cost of this program, and any other funds used that are not the claimant's proceeds of taxes, including transportation and use funds from Measure M2, levied by and received from the Orange County Local Transportation Authority, are required to be identified and deducted from any claim submitted for reimbursement. Finally, all other sections, activities, and costs pled in the test claim are denied as either not imposing a state mandated new program or higher level of service or not resulting in costs mandated by the state. Staff recommends that the commission adopt the proposed decision to partially approve the test claim and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing.
Parties and witnesses, please state your name for the record.
Howard Guest, claimant representative.
Catherine Hagan for the Water Board.
And Michael Lawfer for the Water Board.
And Donna Furby for the Department of Finance.
Thank you. Mr. Guest, for the claimants, would you like to begin?
Yes, thank you. Good morning, Chairperson and members of the commission. Howard Guest for the claimants. First of all, we want to state our appreciation for the amount of work that staff has put into this lengthy decision. We support the proposed findings that certain portions of the permit are reimbursable state mandates. And we believe that those findings are proper. Because the amount of work that went into this decision, we don't want it to see it to be infected by certain errors that can be fixed. So I would like to address two areas of the decision this morning. One, which is the monitoring in conjunction with the stormwater action levels, and two is the TMDLs at Baby Beach. We will continue to reserve all our arguments that we've set forth in our test claim papers, the narrative statement, and the comments, but I will limit my comments this morning to these two areas. First of all, I want to address the outfall monitoring. Section D of the permit addresses stormwater action levels. A stormwater action level is a level of a contaminant or a pollutant in a discharge which will trigger further steps by the permittees. And as part of this stormwater action level set forth in Section D of the stormwater permit, the permit requires the permittees to develop a monitoring plan to sample a representative percentage of major outfalls. And let me just stop for a minute and define a couple terms that we'll be referring to. You may be familiar with them, but just to make sure we're all on the same page. You'll hear me refer to receiving waters. And receiving waters are the water body into which the municipal stormwater permit system discharges. So the receiving water might be Aliso Creek or one of the other creeks or even the Pacific Ocean. That's the receiving water. An outfall is where the stormwater flood control system, stormwater pipe or channel discharges into the receiving water. So what this monitoring plan requires is that the permittees develop a monitoring plan for representative percentage of these outfalls. And then after developing that plan, implement that plan. And based upon test results, if those test results are above the stormwater action level, they've got to take further additional steps. And as is indicated, the proposed decision proposes to find that the development of this plan is a reimbursable state mandate, but the implementation of the plan the implementation of the monitoring, as well as any actions that occurs as a result of that monitoring, are not reimbursable mandates. And we submit that the finding that the actual implementation of the plan and these actions that are taken as a result of finding a stormwater action level are in fact reimbursable state mandates. So it's, first of all, it's undisputed that this monitoring and this monitoring plan is a new program, or it's new. The proposed decision so finds on pages 186 and 187. This representative sampling did not occur under the prior permit. Let me just say, when I make references to the page numbers, I'm referring to the proposed decision, which does have like the first 38 pages of the executive summary. So, but I'm using that pagination. And in fact, the section of the decision that we're talking about is generally found on pages 168 through 196 of the proposed decision. So the commission's staff has suggested that the adoption of this monitoring plan is new and is reimbursable, but not the actual implementation. This doesn't make sense. Let me give you an example, not in the context of stormwater. Suppose the state had ordered a county or a city or a school district to build a building. And the state set forth the specifications for that building or the goals that that building was to accomplish, and that this building was for a specific purpose, to be used only for a specific purpose, and the state designated what that purpose would be. It doesn't make sense for the commission to then say, well, the drafting of the architectural plans for that building is reimbursable, but you know what, city, county, school district, you have other buildings. And in the past, you know, those other buildings are used for other purposes, and people go in and out of them and they use them for other purposes. And so the idea of having a building is not new. And therefore, we'll reimburse you for the architectural plans that you've been ordered to prepare, but not the building itself. Well, that doesn't make sense. If the state mandated a new program, you get reimbursed for the program. Well, it's the same situation here with the stormwater monitoring. It's undisputed that these are new requirements. Yet this commission staff in the proposed decision is proposing that you find, although preparing the architectural plans for the monitoring, preparing the plan is reimbursable, when you actually do the monitoring, you can't. Not because this monitoring had been in existence before, but because you had done other monitoring for other purposes. We submit that the stormwater action level program in section D of the permit, which requires not only the development of plan, but the implementation of the plan, the monitoring plan, are new, and that should be reimbursed. And you should not find it not reimbursable just because there are other programs that address other issues. It's also true for actually the implementation and the work that is done, but we will submit on our papers on that and won't take your time on that issue at this point. The second issue that we find error in with respect to this decision is with respect to what they call the TMDLs at Baby Beach. And again, let me just define a couple terms. TMDL is a short acronym for total maximum daily load. And what a total maximum daily load is a planning device where the water board adopts basically a number which represents the amount of a pollutant or contaminant that can exist in a receiving water without being at such a high level that it impairs what they call the beneficial use, the use of that water for swimming or for fishing or for something of that nature. So the TMDL represents the amount of pollutants that could be in that receiving water, here the Pacific Ocean, without interfering with the use of, in this case, Baby Beach. And part of the TMDL is composed of what they call load allocations, which are non-point sources, which means that it's not a pipe or a channel, and also waste load allocations, which refer to the amount of pollutants that could be in the discharge from a point source, which in this case, not using the technical term, we're talking about the pipe or the channel of the permittee. So what section I of the permit did was they took a TMDL that had been adopted for Baby Beach relating to indicator bacteria, and they put it in the permit. And that TMDL required the permittees to reduce the amount of bacteria in the discharge, in their discharges during dry weather over a 3 and 5 year period, and wet weather over a 7 and 10 year period. It also required implementation of actions to comply with that waste load allocation. Now, it's undisputed that these are new. Okay, the TMDL wasn't adopted till 2009, so it could not have been in the prior permit at the 2002 permit. So this was put into this permit. But the proposed decision, and this section of the proposed decision is found at pages 197 through 227 of the decision. The proposed decisions is that even though the TMDL is new, it's not reimbursable, because under the old permit, there was a different provision that said that discharges that cause or contribute to an exceedance of a water quality standard in the receiving water is prohibited. This section also gets repeated and is included in the new 2009 permit. The proposition that the TMDL is not new because there was this other prior discharge prohibition, which did not reference waste load allocations, did not reference the bacteria, did not reference the time period. The proposition that it is still not new because there was this other prior prohibition fundamentally misunderstands what the TMDL does and requires as compared to the discharge prohibition. The discharge prohibition, and I'm going to bring you back again to the term receiving water, the discharge prohibition prohibits discharges that causes or contributes to exceedance of a water quality standard in the receiving water. The focus is on the receiving water, that water or body, that body of water that is receiving the contaminant. It does not specify any specific action, but and that body of water receives contaminants from many different sources. Compared to the focus of that on the receiving water, the TMDL waste load allocation focuses on the permittee's discharge from its outfall. And that is what is being regulated under the TMDL. So what you have here is a new regulation, new requirements that were not in the prior permit. And the only reason why the proposed decision is proposing to find that it's not reimbursable is because the goal is the same. The standard of performance is the same. What we're trying to do is keep the receiving water clean. And the proposed decision is saying, well, because that goal is the same, it's not new. Well, that's not what the test is. The test for whether something is new was set forth most recently by the Court of Appeal and Department of Finance Free Commission, which is the San Diego permit case, which was rendered in 2022. And that test is to determine whether a program imposed by a permit, and this case also involved the stormwater permit. And so they said the test is to determine whether a program imposed by a permit is new, we compare the legal requirements imposed by the new permit with those in effect before the new permit became effective. In other words, you compare what's required under our new 2009 San Diego permit with the prior permit. And then they say, this is so even though the conditions were designed to satisfy the same standard of performance. And that's where the commission staff's proposed decision errs, because they're saying, well, it's the same standard of performance, clean water in the receiving water, and therefore it's the same. Yet the TMDL is a new requirement, undisputed that it's a new requirement. And so under this case, to determine whether it's new and a new program, you look at what they're requiring the permittees, here the claimants, to do. And that's where the proposed decision errs. And how do you know really that it's new? What's the evidence that this is new as opposed to what was covered by the old discharge prohibition? Well, the discharge prohibition was in the 2002 permit, and the discharge prohibition is also in Section A of the permit. If it was the same thing, you wouldn't need the TMDL. Now, we know that the water boards don't take frivolous actions. We know that they don't take unnecessary actions. So clearly, they felt that they had to require something more of the claimants by putting in the TMDL in Section I. Otherwise, if it was the same thing, they could have just kept the discharge prohibition, which they already had. And for that reason, we request that the commission find that not only is find that the TMDL is a new program. Let me just say in closing very quickly that there's another basis on which the proposed decision appears to find that the TMDL is not a new program. And that is based on statements that federal law requires compliance with water quality standards, and therefore this TMDL is not new. They don't say that this is a federal mandate. They say they concede that this is the TMDL is a state mandate, but they say it's not new because these are required. Well, the concept that federal law requires compliance with water quality standards for these MS4 municipal stormwater permit discharges is wrong. It's simply wrong. And so, first of all, so everybody understands, water quality standards are criteria, levels of pollutants that are in the receiving water, here the ocean or the creeks, again, to protect what they call beneficial uses, the ability to swim or fish in those water bodies. And the proposed decision in 4 different places references the fact that the permittees are required to comply with water quality standards. And as I say, that is just simply wrong. Since 1999, in the Ninth Circuit case of Defenders of Wildlife v. Browner, it's been well established that for municipal stormwater permittees, they are not required to comply with water quality standards. That's referenced by the fact that they compared what the municipal stormwater permittees required to do with what industrial or private parties are required to do with their stormwater discharges. And they said Congress specifically found that the industrial permittee or the other permittee is required to comply with water quality standards, but for municipal stormwater permittees, they have a different standard, not compliance with water quality standards, but reduce the discharge of pollutants to the maximum extent practicable. And the state board, the State Water Resources Control Board, concedes this point. In their decision of which was relating to a Los Angeles County stormwater permit and review of that, Water Quality Order 2015.-0075, they explicitly state In the context of NPDES permits for MS4s, however, the Clean Water Act does not explicitly reference the requirement to meet water quality standards. And then they go on to say they have the ability to not require compliance. They can impose that requirement by discretion, but they don't have to. And so they themselves acknowledge that this requirement is not imposed on MS4 permittees. And I'll just note for the record that there's at least 4 different places in the proposed decision that states that the permittees are required to comply with water quality standards. On page 170, page 189, when they're talking about monitoring, and page 198 and page 222, when they're talking about the TMDLs. So for the reason I first stated, that the TMDL is qualitatively different than the discharge prohibition, and to the extent the second basis is set forth that MS4 permittees have to comply with water quality standards, both of those are errors, and we would request that the decision be modified both with respect to implementation of the stormwater monitoring plan and with respect to the TMDLs. And as I say, we reserve and are not waiving any of the other arguments that we've set forth in our test claim papers or comments. Thank you very much.
Thank you. Next, we'll move to Department of Finance. Do you have any comments?
Good morning, Donna Furby, Department of Finance. We have previously submitted written comment on the test claim, and we won't reiterate those comments here. We will, however, join in the Water Board's remarks today. Thank you.
Thank you. Ms. Hagan and Mr. Lawfer from the State Water Resources Control Board and San Diego Regional Water Quality Control Board, do you have any comments?
Yes, we do. Thank you. Good morning, commission members and staff. My name is Catherine Hagan. I'm with the State Water Board's Office of Chief Counsel. And as you know, Michael Lawfer is also with me here today. The water boards appreciate and also want to recognize the exhaustive work by commission staff in developing this proposed decision that you're considering. We agree with a significant number of recommendations in this proposed final decision. We do want to identify our concern, however, with the proposed decision's reversal from the draft that was circulated with respect to section D2, which is within the stormwater action level provision, section D that Mr. Guest was referring to at the beginning of his remarks. Section D establishes stormwater action levels based on existing water quality standards, and section D2 in particular requires permittees to develop a monitoring plan to sample a representative percent of the major outfalls within each hydrologic sub area. And this is for the purposes of assessing compliance with the applicable water quality standards. Section D2, it's important to note, does not require a monitoring plan for every outfall, just representative percentage of outfalls. This requirement is consistent with the federal MS4 regulations, which require representative monitoring of outfalls. Specifically, the federal regulations require permittees to include a proposed monitoring program for representative data collection for the term of the permit that describes the location of outfalls or field screening points to be sampled, why the location is representative, the frequency of sampling, parameters to be sampled, and a description of the sampling equipment. This regulation is set forth in 40 Code of Federal Regulations, section 122.26 D23 big D. Additionally, the federal regulations at that same section, but ending in 4E, also require permittees to propose a monitoring program that includes a description of the location of outfalls or field screening points appropriate for representative data collection, and a description of why the outfall or field screening point is representative. While the proposed final decision states at page 186 that federal law does not require monitoring of each stormwater source at the precise point of discharge, citing the Natural Resources Defense Council versus County of Los Angeles case, a 2013 federal district court case, federal appellate court case. And it's important to note that the same court decision goes on and recognizes that these federal regulations I described above require that permits contain monitoring designed to yield data that is representative of the stormwater discharges. The court concludes that EPA regulations make clear that while MS4 and PDS permits need not require monitoring of each stormwater source at the precise point of discharge, they may instead establish a monitoring scheme sufficient to yield data which are representative of the monitored activity. The court also recognizes that these federal regulations require permittees to propose a monitoring program for representative data collection that describes the location of outfalls or field screening points to be sampled and explain why the sampling locations are representative. This further discussion in the NRDC case underscores that federal law requires the type of monitoring that is included, a monitoring plan that is included or required to be developed pursuant to Section D2. For this reason, we would ask that the proposed decision be revised to deny the test claim for Section D2 along with the remainder of Section D in its entirety. And finally, while we continue to disagree with some of the other proposed conclusions, we have already expressed these concerns in our written comments in this matter, and so will not reiterate them here today. We appreciate the opportunity to speak with you today and are available to answer any questions the commission may have. Thank you.
Thank you. Is there any public comment on this item?
I'm seeing no hands raised.
Okay, are there any questions from members? Seeing none there, I see Camille came off. Did you want to make the comment?
I'm happy to answer any questions that you might have, and I'm willing and happy to address both the stormwater action level section and the TMDL section if you have questions there.
Yeah, if you want to make some brief comments in response, that maybe that.
Sure.
Yeah.
Sure. So the stormwater action level section, let me just kind of step back and explain what that is. Under prior law, both federal law and the prior permit, permittees were required to monitor wet weather and dry weather samples, analyze those samples, determine the source of any pollutants, and evaluate and modify best management practices to control the discharge of any pollutants to the water bodies. Those are the same activities that are being imposed by the stormwater action level section of the permit. All that a SAL is just a number that reflects the amount of pollutant in the water that you know that is going to exceed water quality standards. Those SALs or action level numbers are the same as the water quality standards that were in prior law. The SALs were determined for or set for nitrate and nitrite, turbidity, and the metals. And the metals all have water quality standards that were set long ago under the California Toxics Rule. So the claimants were monitoring for those pollutants under prior law. They had to analyze samples. They had to determine whether those samples had exceeded those water quality standards under prior law. And they had to evaluate and modify best management practices if they determined there was an exceedance. In fact, the water board found that a discharge of those pollutants were causing water quality impairments, and there were several violations of water quality standards under the prior permit for those pollutants. So none of those activities are new. And in addition, federal law requires monitoring sufficient to determine whether you are meeting water quality standards. We strongly disagree with the claimant that they weren't required to comply with water quality standards under prior law because the state water board issued a precedential order I think back in 1999, that required all the receiving water limitation and discharge prohibitions to be included in permits that did require that they meet water quality standards, and all of those in the basin plan. So none of that is new. The only new part that they had to do with the adoption of this permit was to develop a monitoring plan. And so how they do that is up to them, but the fact that they had to do a new monitoring plan, we felt was a new state mandated activity. And that's why we recommended approval of the monitoring plan itself for the stormwater action level compliance. So that's SALS. The TMDL at Baby Beach on bacteria, very much the same kind of analysis. There you had water quality standards that were set long ago in federal law and in state law for the 3 types of bacteria in coastal waters. State law before this TMDL said that if you exceed those water quality standards, then your beaches have to be closed. So the TMDL set the numeric targets exactly at the same level as the water quality standards in prior law, and simply requires the same activities of monitoring, analyzing the samples, determining the source, and modifying the BMPs. And for the TMDL, they have to meet those water quality standards by the interim and final deadlines. The only difference between prior law and the adoption of the TMDL was that the permittees now know the percentage of bacteria they have to reduce in order to meet water quality standards. There really is nothing new there. The activities that are required to be performed under prior law and under the test claim permit are exactly the same. They just have to do a better job to meet water quality standards. And so that's all that those 2 sections require.
Thank you. With that, is there any further discussion? If not, is there a motion?
Excuse me, Chairperson, would you like me to respond to some of those points? Or
Sure, you can briefly respond.
okay, so first of all, with respect to the TMDL, I'd like to respond to the assertion that it did not require any new activities. And that's not correct. I mean, the goals are the same, compliance with water quality standards at the beach. But the activity that is being ordered is different. And so again, under the Court of Appeals decision in Department of Finance v. Commission dealing with San Diego, where it says that you have to look at whether the legal requirements are the same or different. And it does not matter, even though the conditions were designed to satisfy the same standard of performance. Well, the argument is, well, you had to meet the same standard of performance. You had to meet water quality standards both before and after. But that's not the test. The test is, was there a legal obligation imposed on the permittees? And there was a legal obligation to comply with these waste load allocations that didn't exist before. And that's the facts. And so there's really no dispute about those facts. So that under the Court of Appeals test, this is a new program. And so I wanted to respond to that point. And with respect to the monitoring, we were not obligated, the claimants were not obligated to sample outfalls under the prior permit. Under the new permit, we are required to sample outfalls in wet weather. So that's new. And again, the goal is the same. The goal is always the same. The goal is clean water. Everybody wants clean water. The claimants spend a lot of money trying to achieve clean water. And they do a good job. But in this instance, the state is telling them how to reach that goal. And that then becomes a reimbursable state mandate. Thank you very much.
Thank you, Mr. Guest. looks like you want to make one more comment. Camille, go ahead.
I just need to state that the activities required by the TMDL section to monitor and to amend your BMPs and to report to the regional board are absolutely not new. And the fact that they had to meet water quality standards by performing those same activities under prior law is the fact. So we apparently do disagree with the facts presented. The undisputed facts are, the only difference is that they set a TMDL, a number to determine the amount of discharge reduction in the pollution that you have to reach. But the activities of monitoring, implementing BMPs, and reporting your results to the regional board are absolutely not new.
Thank you. Is there any further discussion? Member Olson?
I'll move the staff recommendation.
There's been a motion to move the staff recommendation. Is there a second?
Second.
The motion to move the staff recommendation has been made by Member Olson and seconded by Member Walker. Are we ready for the question? Or is there further discussion? Seeing no further discussion, Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Evans,
Aye.
Ms. Holman,
Aye.
Ms. Nash,
Aye.
Ms. Olson, Ms. Olson.
Aye.
Thank you. Mr. Steppenshaw,
Aye.
Mr. Walker.
Aye.
That motion is carried.
We will now ask presenters for item 4 to please turn off their video and mute their microphones. Item 5 is reserved for county applications for a finding of significant financial distress or SB 1033 applications. No SB 1033 applications have been filed. Next, program analyst Jill McGee will please turn on her video and microphone and present item 6, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. The governor had until October 14th, 2023 to sign or veto legislation. SB 544, Bagley-Keene Open Meeting Act, teleconferencing. This bill was chaptered on September 22nd, 2023, and is effective on January 1st, 2024. As discussed at the last commission meeting, this bill enacted additional alternative provisions under which a state body may hold a meeting by teleconference, including the following key provisions among several other requirements. The bill requires a majority of the members, a quorum, to be physically present in a single teleconference location, and at least one member to be physically present at each teleconference location, all of which are required to be accessible to the public and from which members of the public may participate in the meeting. Authorizes a member's remote participation, which location is not required to be accessible to the public and which the notice and agenda are prohibited from disclosing if the other members who are physically present at the same teleconference location constitute a majority of the state body. Authorizes a member's remote participation if the member has a need related to a disability and notifies the state body, in which case that member is counted toward the majority of members required to be physically present at the same teleconference location. Thank you.
Does anyone have any questions on that? We will be implementing and working to implement our hybrid meetings for the January meeting, so that we will be able to have participation both remotely and in person at the same time. Moving on, Chief Legal Counsel will please turn on her video and microphone and present item 7, the Chief Legal Counsel report.
Thank you, Heather. We have no new filings and no recent decisions, and there's nothing pending on the litigation calendar at this time. So I have nothing to report.
Thank you. Next is the Executive Director report. Christina Bartiso will please turn on her video and unmute her microphone for her introduction to the commission. And I am pleased to announce that our new executive new assistant executive director, administrative services, Christina Bartiso, who began working with the commission on Monday, September 2025, 2003, is here with us today for her first commission meeting as assistant executive director. Ms. Bartiso earned her bachelor's in business administration from the University of Economy in Romania, after which she attended the University of Law in Romania for a year, which makes her a particularly good fit for the commission with her legal background as well. She also earned her certificate of bookkeeping. And Christina is coming to us from the Department of Education Tobacco Use Prevention Education Program, where she served as a staff services manager 1 and led and supervised a team working on budget, contracts, grants, personnel, legislation, and planning. And prior to her promotion to management, she was an AGPA in a lead capacity working on budgeting, administrative, analytical, and technical assistance for the Foster Youth Services and Coordinating Program. And for those of you who've been with the commission for a long time, you might remember Christina. She also worked at the commission from 2016, 2017, where she adeptly handled the commission's budgeting and accounting functions at that time, establishing new systems and means of tracking critical information. And she also prepared a statewide cost estimate for the commission and was a lot of fun for commission staff to work with. We're delighted to have her as a new member of our executive team.
Thank you so much, Heather. And I'm very glad to be part of to rejoin this great team. And thank you, everyone. And I'm looking forward to working with you.
Thank you, Christina.
Thank you, Christina. Welcome back to the commission.
Oh, thank you.
And next we will go to, our workload update. After this hearing, there are 40 pending test claims, 36 of which are regarding stormwater NPDES permits. There are also 3 parameters and guidelines, 2 statewide cost estimates, and 1 incorrect reduction claim pending. Commission staff expect to complete all the currently pending test claims and IRCs by approximately the July 24th, 2026 meeting. And just as a reminder, we issue our draft analyses for comment at least 8 weeks prior to the hearing, and then our proposed decisions 2 weeks prior to the hearing. You can find all of our pending caseload on our website, which we update, and that's for all caseload, and we update that at least every 2 months. And that's all I have today. With that, we can go into closed session.
Thank you. The commission will now meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1. We will reconvene in open session in approximately 15 minutes.
Ms. Swank, are you there?
Yes, I'm here.
Okay. Mr. Chair, if you'd like to go ahead.
Yes, thank you. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will entertain a motion to adjourn.
So moved.
There has been a motion to adjourn. Is there a second?
I'll second that.
Has been moved by member Nash and seconded by member Holman to adjourn this meeting. Heather, please call the roll.
Mr. Adams,
Aye.
Ms. Evans,
Aye.
Ms. Holman, Ms. Ullman,
Aye.
Ms. Nash,
Aye.
Ms. Olson. We seem to have lost Ms. Olson. Mr. Steppenshaw,
Aye.
Mr. Walker.
Aye.
Motion to adjourn is carried. This meeting is now adjourned. Thanks all.
Thank you. Bye, Sarah. Thanks.
Sorry, I couldn't find the link again.